Ladies and gentlemen, thank you for standing by. Welcome to the Advocating for the Unbefriended Elderly conference call. During the presentation, all participants will be in a listen-only mode. Afterwards, we will conduct a question-and-answer session. At that time, if you have a question, please dial 1-4 on your telephone keypad. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded, Wednesday, August 18th, 2010. I would now like to turn the conference over to Jessica Brill-Ortiz. Please go ahead.
Thank you. Welcome, everyone, to today's conference call on the topic of advocating for the unbefriended elderly, hosted by the National Ombudsman Resource Center. My name is Jessica Brill-Ortiz, and I'm the Program Manager at the National Consumer Voice for Quality Long-Term Care. The issue of unbefriended elders was brought to our attention, and we've conducted research on the topic and developed the informational brief and this call to talk about ways of advocating for the unbefriended elder population. Today's call is being recorded and will feature 4 speakers in addition to myself, and also question and answer opportunities as time allows at the end of the call. To start, I'll provide an overview of NORC's brief on advocating for the unbefriended elderly, which you received yesterday via email. If you have any trouble accessing the brief, it will also be posted on the NORC website along with the call recording in the next week. The brief uses data collected largely from NORC's outreach earlier this year to state long-term care ombudsmen, along with information from the July 2003 American Bar Association Commission on Law and Aging report titled Incapacitated and Alone, Healthcare Decision-Making for the Unbefriended Elderly. The brief defines unbefriended elders as older adults without capacity to give informed consent for treatment, who have no advance directive for the treatment, and who don't have any family, friends, or legally authorized surrogate to be involved in the medical decision-making. Approximately 3 to 4% of the nursing home population is currently considered to be unbefriended. These elders are vulnerable to under or over-treatment, or treatment that doesn't reflect their values and preferences. And there's a great deal of variation in how states across the country assist unbefriended elders. The ABA report that I mentioned earlier identified existing legislative mechanisms related to healthcare decision-making for unbefriended elders, and the brief provides details about the various mechanisms and examples, and I'll give a brief overview today. The first mechanism is state healthcare consent laws, or consent statutes granting authorization. West Virginia, for example, uses healthcare surrogacy. After it has been determined that an individual lacks capacity to make healthcare decisions and does not have a medical power of attorney representative or a court-appointed guardian, a doctor appoints a representative. And the West Virginia Department of Health and Human Resources serves as the representative of last resort. The second legislative mechanism identified in the ABA report is surrogate decision-making committees that exist by statute. An example of this is California's Health and Safety Code, which includes a law that allows nursing homes to establish interdisciplinary teams of facility staff and a patient representative, which could be an ombudsman or a family member, to make decisions about treatment for incapacitated elders. The third legislative mechanism identified is public guardianship. In Massachusetts, for example, the Uniform Probate Code made major changes to the previously existing law related to standards for determining someone to be incapacitated, information that has to be included in the petition for guardianship, rights of those under guardianship, and also constraints on guardians. The last legislative mechanism is court authorization for treatment or guardians for limited temporary medical treatment. An example of this can be seen in Rhode Island, where the mental health court is asked for a petition to instruct, thereby asking the court for permission on a one-time only basis to have surgery or permission for medical tests. As I mentioned, the ABA report also identified institutional practice. In states where there are no legislative mechanisms, such as those just mentioned, for making decisions on behalf of unbefriended elders, and where there are no healthcare consent laws with decision-maker hierarchy, advance directives and guardianship are often the only mechanisms authorized. And so in some instances, communities and institutions have taken different approaches to decision-making on behalf of these elders. These can include ethics committees, informal surrogate systems, and ad hoc procedures. Ethics committees can help to address ethical dilemmas in acute and long-term care facilities, but it's important to note that for the most part, they tend to provide assistance and education and consultation services rather than actually making the healthcare decisions for the unbefriended elders. Informal surrogate systems can occur when the Ethics Committee assigns a member of that committee to an unbefriended individual to act as an informal surrogate. This surrogate relationship usually begins while the elder has some capacity to make decisions so that they can consent to the relationship, and the surrogate can get to know the resident and their preferences and values. These conversations would occur on a regular basis, and they're documented in writing. Ad hoc procedures can include when internal procedures for obtaining consent for treatment, such as the facility administrator or physician giving consent on the behalf of the unbefriended elder. In conducting our research, NORC also came across several states with hierarchy decision-maker laws. New Mexico and Georgia are two of these states, and speakers later on in the call will address these laws in more detail. Also based on our research, NORC identified several programs and practices that appear to have promise. For many of these, continued funding is a challenge, but the underlying work on behalf of unbefriended elders seems to have great potential. One such promising program is the Volunteers of America, Minnesota's Unbefriended Elders Matching Values with Decision project, which you'll hear about again in more detail later in the call. Another promising program is Special Advocates for Elders, which is a Nevada program that recruits, trains, and supports volunteer advocates to form one-on-one relationships with elders. Guardianship judges in the state can then appoint a SAFE, Special Advocates for Elders advocate, to an individual who is under guardianship or who is facing guardianship. A third promising program is the Guardianship Alliance of Colorado. The Alliance provides information and guidance about adult guardianship and also offers a variety of programs and services on the topic. Another promising practice that we've identified is the regular review of individuals' values and preferences and making sure that their advance directive or any other written documentation is up to date. For instance, under Colorado's Medical Orders for Scope of Treatment law, healthcare professionals are authorized to work to prepare advance directives with the individual or their surrogate, and those directives then become medical orders. In our brief, we also set forth strategies and ideas for Ombudsmen on the topic of advocating for these unbefriended elders. The first is to promote, hold, and encourage educational events. One idea is to hold in-service trainings on advance directives for ombudsmen, facility staff, or others. Another idea is to work with organizations, including citizen advocacy groups in your state, to bring attention to the issue of unbefriended elders and to assess next steps and advocacy needs. Education topics could include creating an Office of Public Guardian, promoting the use of advance directives, and determination and assessment of capacity. Another strategy for ombudsmen is to work with state organizations, including your state CAG, for advocacy around various issues in your state, such as decision-maker hierarchy, advance directive changes, limits on guardianship powers, and how capacity is determined, assessed, and reassessed. A third strategy is to learn about institutional practices in the long-term care facilities in your state, such as surrogate systems, ethics committees, etc. So that's a brief overview of our informational brief. It also includes, the brief itself includes policy suggestions related to unbefriended elders taken from the ABA report, as well as additional resources, documents, and sample forms. So at this time, I'd like to turn the call over to Erica Wood, Associate Staff Director at the American Bar Association, Commission on Law and Aging. Erica will provide an overview of ABA's report on unbefriended elders.
Thank you, Jessica, and greetings, everyone. Jessica asked me to talk about two things. The first is to go over the ABA 2003 report on healthcare decision-making for unbefriended elders in a little bit more detail. Jessica has done a wonderful job at hitting some of the highlights, and I'm very excited about the brief that NORC has put together. Secondly, she asked me to address specifically some of the public guardianship issues. So I'll start with the 2003 report on unbefriended and segue into some specifics on public guardianship. So looking at the 2003 report, noted bioethicist Nancy Dubler has talked about the heart-wrenching situation of people with diminished capacity who have no surrogate decision maker, no agent, no guardian, no relative, no capacity to execute an advance directive. In that they fall through the societal cracks. No one cares deeply, she said, about their welfare or whether they live or die. So these are folks for whom little or nothing is known of their past lives and their values. They're really marginal to society, and I'm sure that as ombudsman you've often seen these individuals. No attention is paid to them very frequently, all too frequently. And I like to remember that it's actually a quote, no attention paid. And I think that it's the job of any legislative or practice scheme directed at healthcare decision making for unbefriended elders and other unbefriended individuals to direct attention to these societal loners about the healthcare decision at hand. In 2003, with the support from the Fan Fox and Leslie Samuels Foundation, the ABA Commission on Law and Aging did conduct a study. We actually informally referred to it as our SAD study. And we looked at legal policy and practice options for healthcare decision making for this population. We conducted a whole range of interviews and observed some of these mechanisms in action. We found that there's little or no data on this population at all, and the 3 to 4% is really just a very rough estimate. We also found that physicians in real life simply go ahead sometimes and make these healthcare decisions. We call that acting under the radar screen because there's really no legal basis for such decision making. But sometimes it's in reality the only option, although certainly not the best. I wanted to note that we're talking about major medical decisions, sometimes including end-of-life decisions, but we're not talking here about emergency decisions, because consent is implied for emergency decisions. Now, as Jessica mentioned earlier, we did find 4 legislative mechanisms as well as some institutional practices. The institutional practices centered mostly around various uses of ethics committees. But I wanted to look in a little bit more detail at the 4 legislative mechanisms. The first is, and you've heard various terms for these laws. I like to call them state default surrogate consent laws. You may have heard them referred to as family health care consent laws. Believe it or not, some 44 states now have such laws. And if you look at it's a hierarchy of mostly family decision makers. Nowadays, at the very end, some states are beginning to provide for decisions for individuals who have no advance directive by a close friend, but that won't help our population. About 10 states at the very, very bottom of the hierarchy provide for a mechanism for unbefriended individuals, usually through some combination of a physician, 2 physicians, and an ethics committee. The second mechanism, as Jessica described, is a system of surrogate decision-making committees, which has most prominently been used in New York, which has had such a system since 1985, and it's been statewide since 2001. And it is a system of trained volunteers who have a very specific procedure for making surrogate decisions for unbefriended individuals with intellectual disabilities. It's not a program for older persons, specifically. Third is, as Jessica mentioned, judicial authorization for treatment. We found that in at least 7 states, but of course it occurs as well in other states where a court might, through its inherent power, authorize a specific medical treatment for an individual. One interesting variation on this, and one that I'd really like to see picked up, and it really hasn't been yet, is the idea of a temporary medical treatment guardianship program. That is, a guardian who would be authorized to make one or perhaps a series of healthcare decisions for an individual, but not to be an ongoing or plenary guardian. There's actually a model statute for that, and some early work has been done, but there it stands. The fourth mechanism, and I'll turn to that now, is public guardianships. The ABA Commission, along with the University of Kentucky, did conduct, and some others, notably Professor Windsor Schmidt, did conduct during 2005 to 2008 a national public guardianship study with extensive site visits, survey, and a development of a model statute. And you can see a summary of that on our website. We found that almost all states have some form of public guardianship, but only 44 states have statutory provisions, and also that it's important to differentiate between explicit public guardianship programs and implicit. So an explicit program uses the words public guardianship, and the statute sets up an office with a staff with specific procedures, whereas an implicit program is more a guardianship of last resort mechanism, often naming a state agency as guardianship of last resort if there are no other options. Of the public guardianship programs, we found 4 models as to location in the state administrative structure. Location in the court, an independent state office, the county model, and by far the most common is locating public guardianship program in a social service agency, although that is problematic in that there may be conflicts of interest because the agency would be both providing the services and the public guardianship program would be advocating for and maybe critiquing those very same services. No surprise to anyone, the study found that funding and staffing for almost all of the public guardianship programs are woefully inadequate. Also that the client population has changed in recent years from public guardianship with a much greater emphasis on younger individuals with intellectual disabilities and mental illness. The study recommends a staffing ratio of 1 to 20. Only a very few states have any kind of statutory ratio. As far as, and I'll just wrap this up by, Jessica asked me to address the establishment of a public guardianship program. Actually, the idea that I liked best on that, and I may be a little biased, is the one that came about in Virginia where I live, and that is to begin with a pilot program or two because you probably don't have money for a huge statewide program and you don't want to put it all in place at once perhaps anyway, without first evaluating it. So that's one thought on that. I also wanted to just remark on the importance of data collection before you begin to go about advocating for public guardianship program and try to collect the data to substantiate the need. I think I'll stop there and turn it over to the next speaker.
Thank you, Erica. At this time, I'd like to turn the call over to Sandra Everhart, who's the State Long-Term Care Ombudsman in New Mexico.
Good afternoon. I've been asked to speak to New Mexico's Uniform Healthcare Decisions legislation. For those of you that like to look up laws, you can find it at NMSA 1978, Section 247A-5. The handout that was sent regarding the call outlines the primary components of the New Mexico Surrogate Decision Act. There are a couple of points that I'd like to make. One is the Surrogate Decision Act goes into effect in the absence of a designee, but also if the designee is not reasonably available. And the list in priority, and I think many states have this, the first is spouse. The second in New Mexico is individual in a long-term relationship of indefinite duration. And initially when this was discussed in the legislature, there was some argument that this was only for same-sex couples. That is not true. There are many elder couples who do not want to get married because of problems with children and estates, and they would like to live together and be friends. Also, younger people with disabilities, oftentimes if they get married, one or the other will lose their some of their state or federal income. So the second priority in New Mexico is individual and long-term relationship. Third one, adult children. Fourth, parent. Fifth, adult brother or sister. Sixth, grandparent. And then the next category, if none of the above individuals are eligible or interested, there is a category for an adult who has exhibited special care or concern, who is familiar with the patient's personal values, and who is reasonably able to act as a surrogate. Jessica had asked that I give you some examples of where the Ombudsman program have had to use the Surrogate Decision Act. We had a lady in southern New Mexico who went into the nursing home. She was competent but had some medical issues. She developed dementia, and then she fell and broke her hip, went to the hospital, and needed surgery. She was an unbefriended elder. The individual that finally came to the hospital and signed for her was her minister as her only surrogate decision maker. We have another situation that is currently unfolding. A young man in his mid-20s was in an accident. He suffered a traumatic brain injury. He probably will not recover. He and his wife were separated but not legally separated. She has a drug problem. His parents would like to become his surrogate decision maker, and this statute allows them to take over care of their son, even though he's not legally separated, because we can argue that the wife is not readily available or reasonably available to serve. The other point, two other points I'd make about the New Mexico statute: a healthcare decision made by a surrogate for a patient is effective without any judicial approval. The other point I'd make is that a supervising healthcare provider may require an individual claiming the right to act as a surrogate for a patient to provide a written declaration under penalty of perjury, stating facts and circumstances why they think they should be a surrogate decision maker. So I will wait for the question-answer period, and thank you very much.
Thanks, Sandra. At this time, I'd like to turn the call over to Mary Bournong, Geriatric Care and Program Director for Access Advisors with Volunteers of America.
Thank you. I'm so pleased to talk with everybody today about our pilot project out of Minnesota here called Unbefriended Elders Matching Values with Decisions. First of all, in Minnesota here, I want to explain the advanced directives are called healthcare directives, and the surrogate decision makers named in the healthcare directives are called healthcare agents. And then also for our purposes today, I'm going to be using the terms unbefriended elders and adult orphans interchangeably. Volunteers of America of Minnesota's Protective Services Program, which provides consultation and/or assessments and recommendations to families and professionals regarding conservatorship and guardianship issues, wanted to create systems change in order to meet societal needs and to support the individual rights and choices of those with or at risk of cognitive incapacity who have no surrogate decision maker. Medical care providers depend on an individual's ability to make informed consent decisions or the availability of a family member or legal proxy when capacity is impaired. Medical, social service, and insurance systems often work with adult orphans prior to the decisional crisis, but the case management needed to resolve challenging issues may not be performed due to lack of resources, expertise, protocol, and identified responsibility. Essentially, with this pilot project, we were trying to close the loop, where often the systems in Minnesota will ask people if they have a health care directive, and if they don't, they're given forms to complete. But we aim to take that next step to assist people to actually complete the health care directives. Since August 2008, Volunteers of America Minnesota staff, and one clarification from the brief, the workers actually were not volunteers who did this work. We're all social workers, and I wanted to make sure that you understood that it was professionals actually helping to determine people's capacity and the assessments and to actually do the health care directives, although we used volunteers, which I'll explain in a little bit here. So we worked with healthcare providers, county social services, and community providers to develop a specialized protocol for dealing with adult orphans and work directly with adult orphans on the completion of the healthcare directives. I'd like to talk a little bit about our project partners. First of all, Volunteers of America National Healthcare Facilities located in the Twin Cities here. Volunteers of America Minnesota Senior Services Programs, Evercare Health Systems, Little Brothers Friends of the Elderly, and Anoka County were our initial formal partners, and we worked with them to develop the referral system protocols, and we intended to find out how the program could be embedded within these various systems. We also opened up the program to taking referrals from many other long-term care or assisted living facilities, county programs, and community providers as well. Also part of this project, we're working with Wilder Research, which is with Wilder Foundation out of St. Paul, Minnesota, to complete a program evaluation that will be available in the middle of September of this year. And then we also worked with some volunteers. We worked with groups of University of Minnesota School of Medicine first and second year medical students who accompanied us on home visits with the older adults. The project has been supported in part by a Community Services Development Grant from the Minnesota Department of Human Services and then the Stevens Square Foundation. The pilot project, our service area in the Twin Cities, included Anoka and Hennepin counties, and that we started that project from August 2008, and our funding ran through June 30th of this year. And then now we're serving Ramsey and Washington counties through October 31st of this year. Our goals are threefold with this project: early identification of unbefriended elders and completion of healthcare directives, as well as increased communication between physicians and patients who are at risk of being incapacitated and alone prior to the medical crisis, will avoid inappropriate or unwanted medical care to be delivered to an incapacitated patient who is unable to state his or her wishes. Second, support systems for adult orphans will be identified and supported, and providers will increase capacity to develop and enhance an older adult support systems. Third, this will lead to increased public policy attention on the needs of adult orphans, a group whose numbers will be increasing along with the aging boom. The activities of the project have included the following. We intended to train partner organization professionals to work with adult orphans and to understand surrogate decision-making issues. We also wanted to facilitate communication between adult orphans and their primary care physicians, practitioners, to ensure medical wishes are known, discussed, and documented. We wanted to work with adult orphans to identify a surrogate decision maker when possible, and then to facilitate and distribute completed healthcare directives to the elders themselves, to their healthcare agents, and healthcare and other professionals. Like I was saying before, we have a program evaluation that's underway that we're expecting in the middle of September here, but I thought I'd share with you some information that I tried to keep track of over the time that I've been doing this work. Since 2008, we've provided education and training regarding unbefriended elder issues to 700 professionals in the Twin Cities and statewide. We have had referrals of 78 people into this project, and then since taking referrals since December of 2008, here's just some information about demographics and some things that I've noticed. Again, these are approximations here. About 2/3 of the people were women and 1/3 men served. And then, though we had no income guidelines or criteria, most of the people we served were at 150% of poverty or less. The diagnoses of people who were referred included dementia, schizophrenia, traumatic brain injury, or other multiple complex medical conditions that put people at risk of incapacity. Also, interestingly enough, about 5 to 7% of the adults we served were either adopted or in foster care as children. About 50% had no children of their own, and then many had never married. In the end, it was about 60% of the people who were referred to us that they had their case resolved with a healthcare directive. And of these, 80% actually named a healthcare agent. The healthcare agents named included lots of nieces and nephews, friends, trusted people from the older adults' faith communities, and actually some were adult children who had been adopted out as children and who had recently made contact with their parents, our client. We served people who lived in long-term care facilities, in assisted living, or other community living situations. So again, we're waiting for more analysis through the Wilder Research Program evaluation. I'm guessing that it took about 5 or 6 hours for each adult to complete the entire process. And just to look at the cost here, generally through our programs, we charge about $90 an hour for private pay. So if we compare the cost of this work at about $540 per person versus the cost of an uncontested guardianship process in the Twin Cities of about $3,000, which does not include the ongoing maintenance of a guardian, there is a significant cost savings also to note. I thought it might be interesting to share a case study. I'm going to use the name Helen. This was not her real name. Helen was a 70-year-old woman who was referred to us from Hennepin County Adult Protection. She had bipolar disorder as well as dementia, though she was still being evaluated for the type of dementia. She'd lived in the house where she grew up and had taken care of her parents until they died. She had one brother who was now deceased. Helen had never married and she did not have children. Originally, Adult Protection was contacted by some of Helen's neighbors who had concerns about changes they had seen at Helen's house over a period of time. Adult Protection did investigate, and they found that some of her neighbors had seen Helen's vulnerability, and they took advantage by moving into her house and basically turned her house into a drug house. They had also diverted Helen's Social Security payments to other people. Adult Protection stepped in and helped Helen move to a residential care home, but because there was no one that they could identify as an emergency contact, Adult Protection wanted our program to work with Helen to find out about her health care wishes and preferences, and then also to try to find a health care agent. In the initial assessment, we were able to identify that Helen's brother had had a daughter, Helen's niece, with whom Helen had no contact for about 20 years, or since her brother had died. By helping Helen to identify her niece's first name and how old Helen herself was when this niece graduated from high school, thus establishing the niece's age, we were able to search and find this niece by doing an internet search, just by using Google and other people search sites. Once we located this niece, we provided her with educational materials regarding healthcare directives in Minnesota and what her responsibilities and limitations were as a healthcare agent, as well as giving her listings to local caregiver support services. She then agreed to be Helen's healthcare agent. And by the way, this niece actually ended up being a nurse, so she understood the situation and the need for the healthcare directive. We met a few more times with Helen to help her write her instructions, and then offered to accompany her to her doctor to discuss the healthcare directive, but she declined this since she thought she didn't know her doctor well enough yet. It was a new doctor situation for her. Once the healthcare directive was completed and made legal, then we made sure that the healthcare directive copies went to Helen herself, her physician, her county worker, her niece, the healthcare agent, as well as the residential home coordinator. So that's a good example of one of the successful outcomes for one of the people we served. And though much of our funding for the directive work is ending soon, we are trying to figure out how to consult with other programs to replicate this much needed service, and we're really open to ideas about how to provide this more widely. And so with this overview and the case study, I'd be happy to take questions at the end of this presentation, or there was information provided about my email and phone. Thank you.
Great, Mary. Thank you. I'd like to now turn the call over to Natalie Thomas, the State Legal Services Developer with the Georgia Department of Human Services Division of Aging Services.
Thank you, Jessica. I have a couple of things to talk to you about. One is our Temporary Health Care Placement Decision Maker for an Adult Act, and the other is our medical consent law and the changes that were made to it recently, and how the two actually can be used as instruments or tools in the whole unbefriended elder or vulnerable elderly situation. The Temporary Health Care Act and I'll shorten that name, is actually the older of the two. It came into existence back in 1999. And I'll tell you the reason that it came into existence was because we were having a serious issue with healthcare providers using the emergency guardianship statute when a patient no longer needed, for the most part, acute care and needed to be transferred from one healthcare placement setting to another. And that became extremely burdensome. At that time, Adult Protective Services was within another division of our department. We are under the Department of Human Services. At that time, it was Department of Human Resources, and Adult Protective Services was with the Department of Family and Children's Services, so with the Division of Family and Children's Services. They are now actually a part of our division. They have been for about 5-6 years now. But a number of us, including representatives from the Fulton County Probate Court and the Hospital Association, got together because we recognized that this was a problem, and the guardianship or the emergency guardianship statute was actually being invaded. But the bigger problem was the solution that healthcare providers thought they had was to send those emergency guardianships to Adult Protective Services, and they were actually becoming overrun with that. So we developed this instrument as an alternative, and I have to tell you, for a number of years, it was silent. Nobody actually used it. They didn't call Adult Protective Services as much, but when they did, it was still for the same thing. So Adult Protective Services had to become its own advocate and had to start pushing the Temporary Health Care Placement Act. But it wasn't until Adult Protective Services actually came on board with the Division of Aging Services and just outright refused to accept entry into those emergency guardianship situations that there seemed to develop a new awakening as to the existence of the Temporary Health Care Placement Act. And it's actually an act in two pieces, because the first part of it has a list of people set up in a priority, much like the medical consent law, so that if the patient is unable to consent to a transfer, admission, or discharge from the current healthcare placement setting, doesn't have to be just a hospital, but whatever healthcare placement setting they're in, if they can't consent, then they are able to actually try to find someone on that list. And it's kind of the standard list, and for 1999, it actually included a few more than our medical consent law. So you had the spouse, you had the person for themselves, you had the guardian, you had an agent under a power of attorney, which we had at that time, and you had the children, you had grandchildren, you had nieces and nephews, aunts and uncles, you had all of those on the list. What you did not have and what we could not get at that time, they were adamantly opposed to including that, was a friend. The probate court itself would not let that one pass, and even a number of legislators did not like the idea of including a friend on that list. So the first part of the act actually allowed you to find one of those people. If they existed, they could consent, or they could refuse, or they could waive their right to become involved at all and just say, I don't want to be bothered, I don't want to get involved in this. And if they chose the latter, if they said, I waive my right, or if none of the people on the list existed, there's a second part to this act that allows the health care facility where the patient is at the time of the health care placement setting, allows them to actually draft a petition, a simple petition, and the law actually outlines the information that has to be in there. There's no set form for it. And along with the petition, is required an affidavit from the treating physician or attending physician and an affidavit from the discharge planner or social worker or somebody that they designate to be this other person to actually say and attest to this person no longer needs to be in this healthcare setting, but we have identified another setting that is the best place for this person. So that forced them at least to actually say that there had been some discussion, there had been some determination to see what was best for this person. This is the closest place that we can find to place this person, and there is no one on that list who exists, or we found somebody, that person refuses to speak. But what they had to actually attest to was that there wasn't somebody and that somebody said no. Because if the somebody said no, everything stopped. They were stuck with the patient. So assuming they were moving forward with this petition, they actually could just walk that over to the county probate court. There was no hearing. No hearing is required. If the paperwork is actually in order, the judge approves it, issues an order on the spot. A copy of it is sent to the state ombudsman, who can then make sure that a local ombudsman in whatever area it is actually makes contact and keeps track of that person, make sure they're settled in. And they have 30 days to actually get whatever applications they need to get in place, insurance, whatever needs to be done. They've got 30 days to do that, and then the authority ends. That's all the authority that there is with that Temporary Health Care Placement Act. It is used a lot more frequently now, and it's used probably more out of default than anything else because healthcare providers are being forced to use it. So I get a lot of calls, and some of the calls I actually have to walk them through because the first thing is the calls come in and I've heard something about this Temporary Placement Act. I don't know what to do. Where's the form? Well, there is no form unless the local court has created its own. There's no form in the statute. This is all the information that you have to have. Well, why can't Adult Protective Services do it? Well, this was created so that they don't have to. This person is a problem for you. Now you have a mechanism to do something about it. You can move them to another setting if you found a more appropriate setting for them. So it forces them to actually do that themselves. What I've also found is, in one of the more recent calls I've had, family members were actually out of the country, but the hospital had actually made contact with them. And the request from the family was, we're cutting our trip short, don't do anything, we're on our way back. But I had to continue asking questions to get to, did you find any family members? Well, yeah, but they're out of the country. Well, did you talk to them? Well, yeah, we did, but they're in Paris. Well, did you tell them what was going on? Yes, I did. What did they say? Well, they said that we should do nothing. They are cutting their trip short. They're on their way back. And at that point, I stopped them. Well, you don't need to go forward with the petition because they did not waive their right. They're on their way back. So you can do nothing until they get here. But they were actually in the process of trying to proceed with the petition. The other tool that we have is not new. The medical consent for surgical treatment or consent for surgical or medical treatment is not new, but it has been amended as of this last legislative session. So we haven't had an opportunity to evaluate what these changes are going to be like, but some of the differences are added to the list of people who can consent to surgical or medical treatment, adult grandchildren for their grandparents, aunts, uncles for their nieces, nephews, and vice versa. This was already in the temporary health care placement, so this was added to the medical consent. What is very new is that for the medical consent, after many years of fighting against it, added was an adult friend with some qualifications. The friend has to have exhibited special care and concern for the person, They have to have some familiarity with their health care views and their wishes or their desires. They have to be willing and actually able to become involved and willing to act in the person's best interest. But if they are actually willing to meet all of those guidelines and they're willing to sign and date all of that, an adult friend can actually make this call now. And expressly written into the law is the ability of this friend to visit. Now, that's the first major change that was made. The second part of that is if, again, divided into two parts, if there is no one on the list, a new procedure has been put in place. There is an alternative, and this alternative is called a temporary medical consent guardian. So it sets up a new process within the guardianship statute itself for a person to be appointed on a temporary basis to make medical consent or make medical decisions for the person. It can last as long as 60 days or until the court removes the person or until a regular guardian is appointed or until the end of the hospitalization itself. But it goes similarly to the guardianship process. The proposed medical ward, as the person is called, is entitled to an appointment of counsel. Now, the way this kicks off is if the patient is without capacity to provide consent or to make consent for him or herself. However, the same person can petition the court for a medical consent guardian. So, not quite sure how that capacity issue. I did raise that during the legislative session, but that kind of glossed over. But upon the appointment of counsel, there has to be a hearing scheduled within 72 hours, and the court must either appoint the temporary medical guardian or set it up for an evidentiary hearing. And if it's going to be an evidentiary hearing, then it has to be held within 4 days so that the court can make a determination of whether or not to actually appoint this temporary medical consent guardian. The temporary medical consent guardian would have the power to make whatever decisions are necessary. There is one restriction. They cannot withdraw life-sustaining procedures unless the court specifically provides authorization. Now, the way it's phrased, the restriction is limited to withdrawing life-sustaining. It says nothing about withholding it before it's actually implemented. So don't really know how that one is going to work. As I said, this is still relatively new. This was just signed in April, so we've not had a lot of time to evaluate this one. But these are the current. This is the current status of our tools for right now for Georgia.
Thank you so much, Natalie. I think that we've got some time now. We've got about 25 minutes for question and answer. So, Lindsay, if you could help facilitate that.
Thank you. Ladies and gentlemen, if you would like to register a question, please press the 1 followed by the 4 on your telephone keypad. You will hear a 3-tone prompt which acknowledges your request. And if your question has been answered and you need to withdraw your registration, you may dial 1-3. Again, to register any questions, please press 1-4 on your keypad. And our first question comes from the line of Genesis Cashadon. Please go ahead.
I just wanted to know if handouts on today's conference will be available online or available for purchase?
Sure. A recording of the conference call will be available on the Ombudsman Resource Center website for free to download and listen to, as well as a copy of the brief that I gave an overview of at the beginning of the call. You should have received that over email, but again, those will both be on the website. And I know that some of the speakers, Mary, for instance, in Minnesota, does have a lot of handouts that she's happy to share, if that would be helpful as well.
Great, thank you.
This is Erica Wood. I just wanted to add, I neglected to do that earlier, that on the ABA Commission on Law and Aging website, there is some helpful information. There is a chart of all of the state default surrogate consent laws, all 44 of them, including those that have at the very bottom a close friend who's familiar with the values, and further including those 10 states that have provisions for unbefriended elders. In addition, on our website there is, while the 2003 study is not on the site, you can go to the site in order to order it. And there is also a summary of the public guardianship study on the website. And the website is www.abanet.org/aging.
Can you repeat that again? I'm sorry?
Yes. The website is well, actually, let me revise that, because we now have a revised website. You should best go to http://new.abanet.org/aging, and from there you'll see that there are sections over on the left on healthcare decision making, on guardianship, and on all of the publications.
Perfect.
And the center will also collect these resources and put them on the website with the other materials I mentioned, and we can provide a link to the ABA website as well, so it's all in one place for you.
Our next question comes from the line of Susan Guerin. Please go ahead.
Ms. Thomas, please clarify who can or must initiate the temporary guardian for health care, and who pays for that proceeding?
Okay, are you talking about the temporary medical consent?
Yes, ma'am.
Party. Any interested person can actually do that, including the patient who doesn't have the capacity to consent. So anyone can do it, and whoever files it, it's incumbent upon that person or that entity to pay the costs.
So the hospital or nursing home could initiate that?
Correct.
Without a conflict of interest?
Correct.
Thank you.
The next question comes from the line of Joe Rodriguez. Please go ahead.
Yes, thank you. Thanks to all the speakers who talked this afternoon. I had a question for Sandra in New Mexico. And this is in regard to, what does an ombudsman do in the situation where there is no surrogate decision maker, no advance directive in place, and an ombudsman is trying to investigate and resolve an issue or a concern or a problem that an unbefriended elder who lacks decision-making capacity has? Sandra, do you have any protocols or procedures in your state for how an ombudsman would address that situation?
Good afternoon, Joe.
Hi.
We do have a program policy. We do follow the Surrogate Decision Making Act when at all possible. If we have a situation where there's a complaint, we have the authority under state statute to initiate either a systemic investigation of the entire facility, or B, an individual complaint without the surrogate decision maker's permission if we cannot easily and readily get a hold of them to make a decision. This is assuming the resident lacks capacity. So that's under our state statute. We can continue an investigation. We do, of course, try whenever possible, to get the resident and or family to sign for permission for us to go ahead. But if we can't get that, we do have the authority to go ahead on behalf of the resident. And we have, in the two examples I gave, we have taken the lead as an advocate to see to it that these individuals, both the lady down south, we were the lead in making sure she had her hip reduction surgery and getting somebody to sign, because the hospital wasn't going to do it until the nth hour without somebody to sign. So we're very active when we're confronted with those situations.
Thank you.
All right.
Our next question comes from the line of Benson Nadell. Please go ahead.
This is Benson Nadell from San Francisco Ombudsman. I have a question. Has any one of your speakers addressed a parallel issue where someone with dementia and lacks any surrogate or close friend is being given psychoactive medication for behavioral management? Per the OBRA Nursing Home Reform Act, consent for psychotropic medications must be given by somebody, and I imagine that would be a systemic issue. Has anyone addressed that issue in terms of the consent to psychotropic medications for behavioral management?
I can answer that. As far as New Mexico is concerned, if the first thing we would do is check the resident's chart and make sure that the psychotropic is consistent with the diagnosis. If psychotropics are being given for depression, we would consider that an immediate report to the, for us, Department of Health. They are the regulating agency, and they would then initiate a complaint investigation into the use of psychotropics for non-psychotropic reasons.
Okay.
As a reminder, ladies and gentlemen, if you would like to register a question, please dial 14 on your telephone keypad. We are not seeing any further questions at this time.
Okay, well, I'd like to respect everyone's time and thank everyone for joining us on the call today, and especially thank you to our speakers. Again, all of the information from today's call, the recording, the brief, and the various resources and website links that folks have mentioned will be available for free on the National Ombudsman Resource Center's website in the next week. So please check there, and if you have any specific questions, feel free to contact me at the Consumer Voice. Thanks, everyone, and have a good rest of your day.
Ladies and gentlemen, that does conclude the conference call for today. We thank you for your participation and ask that you kindly disconnect your lines.